So in this installment, we're going to talk about the instructional program in a school, and a little later on in the next installment, school desegregation. The legal authority for defining the curriculum of public schools generally resides with the state legislature. This duty is shared between the legislature and the State Board of Education in a few states based on constitutional provisions. The legislature, at its discretion, prescribes the basic course of study, testing, graduation requirements. In most cases, the legislature delegates curriculum matters to state boards of education and to local school districts and local school boards. Almost every state requires children between certain ages to attend public, private, or home school. This is the compulsory attendance provision. It's generally between 6 and 16, although it varies a little bit state to state and even district to district. For example, Kentucky allows districts to approve compulsory attendance until age 18. Biting v. Lee is one of the examples of case law around compulsory attendance. It's a New York case. The school's policy required students to attend 90% of all classes in each course to graduate. The policy required schools to drop students from any course in which they had been deliberately absent. A group of students brought a suit alleging the denial of credit for a class is tantamount to dropping a student from enrollment, which is contrary to state law. The district filed a motion for summary judgment, which was granted by the courts. Students appealed to the New York State Supreme Court, and the court rejected the students' argument and held that a denial of credit was not equivalent to being dropped from enrollment, since it did not prevent them from attending class or attending makeup classes. Reasonable attendance policies will be supported by the court where students deliberately fail to attend classes. Academic credits may be lost when students willfully fail to attend. States may, at their discretion, allow attendance exemptions for married students attending public schools, and parents who violate compulsory attendance laws regarding their children may face criminal charges. Students who violate compulsory attendance requirements may be suspended or expelled, depending on the severity of absenteeism. Truancy involves intentional and unauthorized absence from compulsory schooling. Truancy involves unexcused absences by students without parental knowledge in many instances. Depending on the number of authorized absences, a student may be denied course credit unless those days are made up through detention or summer school. Some states penalize parents if compulsory age students who are truant on a consistent basis. Penalties may include fines or jail times. School districts employ attendance officers, in Kentucky called pupil personnel directors, to monitor students who are truant based on policy. Students may also be prosecuted in some states for violating truancy laws. The other element is that state statutes mandate attendance for students, and parents may also be prosecuted. The school voucher issue, as well as the tax credits that are being used and attempted in states like Kentucky, tend to create a lot of debate regarding their viability. Vouchers allow parents to cover their child's education through the use of federal funds, state funds, or city tax funds. The amount of the voucher generally comparable to the amount allocated to public schools for each child's education, $4,000, for example, in Kentucky. Those who support vouchers suggest that they weed out poorly run schools, thereby allowing parents a choice for good schools for their children. They also cite more parental choices based on their child's skills and differences. Those who oppose vouchers argue that only parents of good students typically make those choices, leaving schools with children whose parents are not as engaged in their education. Additionally, they cite the risk of creating segregated schools, as well as widening the gap between the haves and the have-nots. The Zellman v. Simmons-Harris case, the U.S. Supreme Court held that vouchers issued to parents of students who attended parochial schools did not violate the First Amendment separation of church and state. The point of emphasis in this case is that the program in this case, served a secular purpose, not a religious purpose. Aid was awarded to parents rather than schools. A broad class of students was covered by the voucher program, and the program was deemed to be neutral with respect to religion. Parents were provided adequate non-religious options regarding vouchers as well. Homeschools are another hot issue, especially since the pandemic. Virtually every state in the nation makes provisions for homeschooling. Minimum standards for homeschooling vary among states based on each state's compulsory attendance laws. Minimum standards for curriculum and instruction, length of instructional time, number of days of instruction is to be provided, generally prescribed by statute or state board of education policy. In Kentucky, those standards are very low. Occasionally, conflicts arise between parents and the state regarding the rights of parents in homeschooling their children. A Michigan case, a group of parents decided to educate their children using a home-based program for which they purchased from a private school corporation. They were charged with truancy, and they, along with the private corporation, sued the school superintendent of the state, claiming their constitutional rights had been violated. They further claimed that they had a constitutional right to educate their children at home and were denied due process. The district court removed the private corporation since it wasn't considered an association of members, rather a private business marketing services. The district court held for the state, holding that a right to education for a child at home is not a fundamental right guaranteed to parents. Parents have a constitutional right to send their children to private schools and choose such schools that offer specialized instruction. The fact that the state required certified teachers to provide instruction in courses comparable to those offered in public schools is not an unreasonable requirement. And then parents are not members of a protected class when it comes to discrimination based on groups who wish to educate their children at home. Health requirements are another area that has reared its head since the pandemic, and states, through their police powers, have the responsibility to protect the health, safety, and welfare of children enrolled in public schools. Through their powers, states typically require medical examinations, certain immunizations as a prerequisite of school admission. The most common challenge faced by districts as agents of the state are objections to immunization by parents who claim that immunization violate their rights to free exercise of religion. The courts, for the most part, have supported school districts in their requiring specific immunizations to prevent communicable diseases. Courts have viewed the state's interest in health, safety, and well-being of students to be more compelling than parents' interests. Although exemptions do exist for people on religious grounds in many places, including Kentucky, consequently, parents have been convicted and fined for failure to have their children vaccinated as a condition for admission in public schools. Some states, these exemptions in some states are allowed as long as the welfare of other students is not jeopardized. An example of this is the court's stance on religious exemption that is illustrated in several of the different cases that have generally supported the need for states and school districts to balance the religious views of parents against the state interest in health and safety of students. Residence requirements are also important, since public schools have a leading responsibility to educate children who reside within their boundaries. Residence at a student's actual dwelling place is often controversial. Students may also have a domicile, which is where the student intends to remain indefinitely. An example of the court's position that schools must educate school-age children who reside within their districts with intent to remain is illustrated in the case Byrd v. Livingston Independent School Districts, where in this case, grandmother of 3 young children sought an order to permit their children to attend school in the community where she lived. The children had resided with their grandmothers for a considerable period of time, but not as their primary purpose of attending school. The grandmother was not the legal guardian of the children, and the district contended that the children could not establish residency apart from their parents or legal guardians. The court disagreed and issued an order requiring the district to admit the children. So children living apart from their parents or legal guardians for a considerable amount of time must be admitted to a school in the district where the children are located. Denial of their right to a public school education is a violation of their constitutional rights of equal protection under the law. The physical presence in a particular place for an extended period of time with an intent to remain is tantamount to establishing residence as viewed by the courts. Getting into the instructional program with curriculum, minimum curricular standards in public schools are generally established by state statute and policy. Certain courses and minimum achievement standards are determined through such policy, and local districts may establish additional standards as long as they don't contradict state requirements. Courts generally are very reluctant to intervene in matters involving public school curricula based on the view that states retain the authority to establish curriculum standards and require compliance so long as there's not a federal constitutional infringement. Although curriculum matters are left to educators, this does not negate challenges by parents regarding content-based issues involving textbook and other curricular matters. This is illustrated in many of the cases that we are seeing today, from banning of textbooks to critical race theory questions. And generally speaking, the courts, particularly when it comes to special interest groups that have attempted to influence discussion regarding school curricular activities, particularly with respect to textbooks. The special interest groups generally are conservative and oftentimes base opposition in certain school books due to political, religious, or philosophical viewpoints. In some cases, these groups raise objections to certain content that's inconsistent with their values, but they do so without regard to the overall literary value of the work. The Counts v. Cedarville School District case is a good example. This is an Arkansas school board that voted to restrict student access to Harry Potter books based on the view that the books promoted disobedience and disrespect for authority. Additionally, these books dealt with witchcraft and the occult, they alleged. Consequently, students in the district were required to obtain a signed permission slip from parents or legal guardians prior to borrowing any of the Potter books from the school library. The district overturned the board's decision and ordered the books be returned to the unrestricted circulation area. The point of emphasis here is that students possess First Amendment rights in a school setting, as we've established. The right to read a book is an aspect of the right to receive information. The school library is an environment especially appropriate for the recognition of First Amendment rights of students. The courts take First Amendment rights very seriously, even where there are small infringements on free speech in school libraries. It will be interesting to see as things change and as some of the new cases with the more restrictive state laws, such as those passed in Florida and in Tennessee, lead to any differences of opinion from courts as they uphold those. Those school districts in Tennessee and Florida are complying with those state laws, but there are those that are challenging those state laws. And so once those cases get to the courts, we'll see perhaps some differences of opinion based on some of the prior precedents. As far as grading and academic requirements are concerned, courts are very reluctant to interfere in cases involving academic matters. The prevailing view among courts is that the academic matters are best handled by professional educators, particularly those involving student evaluations. Courts further recognize that there is a certain degree of subjectivity in evaluating students. Requirements regarding student progress from one grade to another are typically not reviewable by courts unless there's a substantial evidence of unreasonableness, as cited in several of the cases. One in particular is a case where a student failed to pass third grade because of a reading test, and the courts were reluctant to interfere and change the outcome of that student's passing into the next grade level as a result of their performance on the reading tests. Grade reduction for absences is another area where the courts generally support reasonable policies regarding these things. There are cases in Michigan and several other states where students have been suspended from school or absent from school and have led to additional missed study sessions and a failure to comply led the student to lose letter grades, and the students generally, the courts have supported these type of policies, as they have supported policies for requiring grade reduction for academic misconduct. Now, the issue of withholding diplomas is probably the exception. School officials are delegated the authority to determine when a student has completed the required curriculum, entitling him or her to their diploma. When the student has met those necessary academic requirements, the diploma must be awarded. Participation in the ceremony to award the diploma is a different issue. A student may be denied participation if there's substantial reasons for doing so. There's no problem denying participation if the student receives the diploma they've earned. The Valentine v. Independent School District of Casey case is a good example where graduating students refused to wear their caps and gowns required for ceremony because they said they smelled. Their diplomas were withheld based on non-participation in the ceremony, and the court held for the students, saying that they can't compel those students to do that and deny their diploma for that. They can compel them to do that, but they can't deny their diploma for not doing that.